Judge. The agreed upon disposition for count 1 is 20 years in the Department of Corrections with credit for 470 days time served. For count 2 is going to be concurrent 20 years in the Department of Corrections with 470 days time served. And for count 3, it is going to be a concurrent 15-year sentence with 470 days time served with, cost of prosecution, cost of defense, and court costs.
No issue as to restitution?
Please,
Do either the victims or crime compensation fund?
Crime compensation paid anything towards this claim, Your Honor.
And no other?
We have the victims are here, like the survivor and family members. Like she prepared a victim impact statement, and we can address that with her at the time. It would be a judgment, though.
I understand. I didn't know if there were funeral expenses or other things.
I didn't see anything that was submitted, but perhaps with the inquiry of Ms. Crow, we can find out what those figures are.
And if that's an issue, you request that if there's no agreement as to the amount, that amount be restitution be reserved for a period of time to allow for hearing on that.
Yes, ma'am.
That agreeable with the defense?
That's all agreeable, Judge.
Your Honor, just one thing before we, and it's just semantics, but there's plea negotiations. The actual plea offer was made by the defense to the state. We accepted the offer. Plea negotiations between the parties. It's just semantics, but I just wanted to be clear.
Oh, I'm sorry if I didn't mean to state that agree. That's just out of habit, Judge. That is accurate as to how it went. I didn't mean to imply otherwise.
Well, and that is often the case in these types of cases, that there's offers or counter offers. You heard what your lawyer just indicated. Is that what you want to do, Mr. Ricks? All right, swear him in. Before I accept the plea, is there some victim impact that you want me to consider?
Yes, Your Honor. I did want to advise the court, although there's a negotiated disposition between the state and the defense, we did communicate. We, pursuant to our constitutional obligation with the surviving members of the victim, they are present. His grandmother is present. Her name is Kim Crow. As I provided to the court yesterday and advised the court yesterday and Mr. Dowdy that the survivors are not agreeable to the disposition in this case, which is 20 years in prison. However, she did prepare a supplemental victim impact statement that is more in line with the statutory requirements. And so she would like to present that to the court. Actually, it's Ms. Crow's statement. She is the victim's grandmother, but she wasn't quite sure if she would be able to get through the statement. Her representative would be her friend, Kaylin Carr. So they both like to come forward, and Ms. Carr.
All right, that's fine. You can take a seat at council table. For the information of both parties, the court had done a notice of filing on June 14th in conjunction with the letter that was received from a letter that was emailed to my judicial assistant from Kim Crow, a 2-page letter. I did review that in advance of the hearing, and copies were sent to both the state and the defense. Right.
We did get another statement from Ms. Crow.
I haven't seen that.
Later in the day. Okay.
If you have a copy, I'm happy to look at it now.
Indicating it's agreeable to the plea agreement.
Step forward, ma'am, please, and be sworn, and you can tell me what you'd like to tell me.
Do you solemnly swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth, so help you God?
If you identify yourselves for the record, please.
I'm Angela Anthony. I'm a victim advocate at the state attorney's office.
My name's Kim Crow. I'm maternal grandmother.
My name's Kaylin Carr. I'm a friend. Okay.
And let me ask that you speak loudly and clearly, number one, so everybody can hear you through these masks. It makes it quite difficult. And as you can see, there's no court reporter because we use an electronic court reporter, and it's important that what you say is not only heard by the people can hear but accurately recorded for the record.
Honorable Judge Alva, the actions of Mr. Ricks have deeply affected my life. Since he committed this crime, I am unable to sleep. I barely leave my house, and my enthusiasm for activities I enjoyed prior to this event are no longer there. My anxiety levels seem to be easily triggered, and I fall apart when I hear of someone being shot and murdered. I cannot help but think about the victim's family and that they are in the beginning stages of this horrific journey. I think about our family and the struggle we experienced right after Bryce's murder. Mr. Rick's crime has also impacted my performance at work. I'm easily distracted. I miss deadlines, and I worry that my boss will at some point realize that I am not an effective supervisor and my performance warnings will begin being issued. I have been 15 years with my company and never had any issues. I do not agree with the plea deal presented today. I feel that Mr. Ricks needs to spend at least 40 years in prison for this crime. People should not be able to commit murder and be sentenced to only 20 years. The emotional impact felt will never go away. Mr. Ricks needs to be held accountable for this crime. Very truly yours, Kim Crow.
Else that you'd like to tell me?
No.
We confirm with the victim there's no out-of-pocket for restitution, Your Honor. Thank you.
Can you step forward? And before I impose a sentence, let me indicate, Ms. Crow, I value your input and I certainly empathize with your loss. These circumstances, as in all of these types of cases, there's no sentence that can be imposed that would restore you to the position that you were in before this happened. The state has the opportunity and the obligation to evaluate every case and to make the best decisions that they can make, considering all the factors in the case, both the nature of the charges, the defendant's prior history or lack thereof, the conduct of the alleged victim in the case, all types of potential circumstances involving the crime itself and any potential mitigating factors involving the defendant in determining what offer they feel is a fair and just offer in the case. And that's not a decision that's made lightly by anyone involved. And while I understand your feelings, and again, I'm sure that there's no sentence that would really be satisfactory in this case if you get to the bottom line to you or to your family. But there's a number of factors that have come and brought us to the position that we're in today, and under the circumstances in this case, the court will accept the negotiated plea. I've been handed a score sheet totaling 430 points. Are you in agreement with the score sheet?
Yes, Judge.
Court will accept the score sheet.
Raise your right hand to be sworn, please. Do you solemnly swear or affirm that your answers to the court's questions shall be the whole truth and nothing but the truth, so help you God?
Yes.
And for the record, I just want to clarify, this is a stipulated downward departure sentence, and the state is waiving the minimum mandatories that would be attenuated to the firearm riders in all of these cases.
Yes, ma'am.
That's correct, Judge.
Are you on Thay Douglas Ricks? How old are you, Mr. Ricks? Okay, can you speak up a little bit with the mask or nothing?
21.
You can keep your mask on, just speak a little bit louder. How far have you gone in school?
11th grade.
Do you read, write, and understand the English language?
Yes, ma'am.
And are you a citizen of the United States? You understand if you are not a citizen, entering a plea to these charges will result in your being deported from the United States. Have you had an opportunity to fully discuss your case, including any possible defenses you may have to these allegations, with your lawyers, Mr. Shapiro and Mr. Dowdy? Are you satisfied with the advice and counsel they've given you? You understand that the maximum penalty that the court can impose for count 1, second-degree murder, is life imprisonment. It's a first PBL and a fine of $10,000 or both. Likewise, as to count 2, life imprisonment. Did you take out the reclassification in that, or you left?
I just left that out, Your Honor. It's on the score sheet.
I'm talking about in the plea form, it says reclassified.
Oh, if I had left that on there, Judge, that just might have been a
It's the
miscommunication.
first PBL, not.
Yeah.
All right, I'll line through that with your permission and correct it.
Thank you.
Count 2 is a first-degree felony punishable by life with a maximum of $10,000 fine. And count 3, a second-degree felony punishable by 15 years in prison and a fine of $10,000 or both. Do you understand that? You understand that in addition to any sentence this court imposes, in the future you could be subject to civil commitment, including confinement, under what was formerly called the Jimmy Rice Act.
Yes, ma'am.
Other than what's just been discussed here in open court on the record, has anybody promised you anything in order to get you to enter the plea? Has anybody pressured you or threatened you or coerced you in any way to get you to enter the plea? Have you had any drugs or alcohol, including any type of prescription medicine, within the past 24 hours? Do you suffer from any physical or mental health conditions that could affect your ability to think clearly or to exercise good judgment? Do you feel that you have a good understanding of the charges against you and what's going on here in court this afternoon? I've been handed a written plea form. Have you read this plea form completely? Do you understand everything the plea form states? Is that your signature on the plea form? Do you swear that everything in the plea form is true and correct? Do you understand that by entering this plea, you're giving up your right to a jury trial? Giving up your right to see and to cross-examine the state witnesses? Giving up your right to call witnesses of your own and to present any defenses you may have to the charges? You're giving up your right to appeal anything except for an illegal or unlawful sentence. And you're giving up all of the other rights set forth in the written plea form. Are you willing to give up all of those rights? State furnish a factual basis for the plea?
Yes, Your Honor. In this case, for the trial, the state would show through confident sworn testimony that on or about January 1st of 2018, the defendant set up a drug transaction with an individual named Bryce Williams, the victim in this case. The actual purpose of the drug transaction was not for the defendant to purchase drugs from Mr. Williams, but was for the defendant and 3 other individuals to actually rob Mr. Williams of either drugs or money. The defendant went to Lake Hodge Park in Casselberry with 3 other individuals, those being Giovanni Villani, Tyreek Green, and Malachi Goodson. They went to Lake Hodge Park at night, approximately 9 p.m. The defendant at the time was in possession of a loaded handgun and approached the vehicle that the victim was driving. He went to the driver's door. The victim was stopped, but the vehicle was still running. He opened the car door and put his hand inside of the car, and it was the hand that was holding the gun, and discharged the firearm inside the vehicle, resulting in the death of the victim, Bryce Williams. The state would show that the above actions of this defendant were imminently dangerous serious bodily injury by his actions. The act was done with an evil intent, that being a robbery, and such actions of the defendant indicated indifference to human life. That's as to count one. As to count two, the state would show through competent sworn testimony at the same date and location the defendant entered a conveyance operated by Bryce Williams without Mr. Williams' permission by opening the driver's side door of the conveyance and placing his hand or arm inside the conveyance. At the time that he entered the conveyance, the defendant had the intent to commit a robbery, and that during the course of the robbery, the burglary, the defendant committed a battery in that he discharged a firearm that resulted in the death of Mr. Williams. As to count three, this would be the attempted robbery. They would show through competent sworn testimony that on the same date and time, the defendant attempted to take money or property, that property being drugs, from Mr. Williams, that the defendant used force, violence, or assault to put fear into Mr. Williams, that the property taken was of some value, it was either marijuana or money, and that the purpose of the taking was to temporarily or permanently deprive Mr. Williams of the property, that being the drugs or the money, and that he used an intentional and unlawful threat to commit the robbery or attempt to commit the robbery by bringing out a loaded handgun and displaying the handgun and ultimately shooting the handgun at Mr. Williams.
Defense stipulated if called upon to do so, the state could establish the proffered factual basis by competent evidence. Do you agree with the facts just stated by the prosecutor, Mr. Ricks? Has the state furnished full discovery in this case to the defense?
Yes, Your Honor.
Based on your knowledge of the case, Mr. Feliciani, is there any evidence that exists which, if tested, could yield exculpatory DNA results?
There is no exculpatory DNA.
Have you reviewed that discovery with your client, Mr. Shapiro?
Yes, Judge.
Are you aware of any such evidence? Mr. Dowdy? Mr. Ricks, are you aware of any evidence in your case that you think, if tested, might produce DNA results that could help you out in this case?
No, ma'am. No, ma'am.
Do you have any questions about anything? Court finds the defendant to be alert and intelligent, finds the pleas to be freely and voluntarily made with knowledge of the consequences after advice of competent counsel with whom you say you're satisfied. Court finds sufficient factual basis for the pleas based on the proffer of the state, stipulation of defense counsel and defendant, and the court will accept the pleas. Here's your client's entitled to a PSI. Are you waiving that? Yes, sir. I did hand the score sheet to a total of 430 points. Are you in agreement with the score sheet? The court will accept the score sheet. Any legal cause why sentence should not now be imposed? At this time, as to counts 1 and 2, the court will adjudicate you guilty of each of those offenses and sentence you to 20 years in the Department of Corrections on each count, with credit for 470 days time served on each count, both counts running concurrent with each other. Civil judgments against you for $100 cost of prosecution, $100 cost of defense, and statutory court costs that total $618. There's a provision for cost of investigation, but I don't see an affidavit.
One was not submitted, Your Honor.
We can strike that, Judge. Thank you.
I'll run through that down with your permission.
Thank you, Judge.
As to count 3, court will adjudicate you guilty, sentence you to 15 years in the Department of Corrections. For 470 days time served. Do you agree that's the correct amount of credit?
Yes, ma'am.
You've got 30 days, so all counts are running concurrent with each other. Do you understand the sentence the court's just imposed? You've got 30 days to appeal the judgment and sentence of the court. Is it your intention to appeal or to accept the court sentence? All right, you need to step over with the court deputy and be fingerprinted.
Good luck, Ms. Rose.
The Department of Corrections. I love you.
Judge, that's all I have this afternoon.
And Jaheim Hawley was, had to be rescheduled. Mr. Jackson was in trial. Mr. Babcock's aware of that. In recess at this time.